State may call us next witness.
State calls Dr. Amanda Gugliano.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat. Again, you don't have to talk directly in the microphone, but make sure that gentleman up there can hear you, okay?
Yes, sir.
Do you understand you're now under oath and your answers will be sworn answers under penalty of perjury?
Yes, I do.
All right, you may proceed.
If you would, state your name for the record.
Amanda Gugliano, Gugliano.
And Dr. Gugliano, where are you currently employed?
I currently work at Mississippi State Hospital, and I also have a private practice where I do forensic psychological evaluations.
And if you could tell us just a little bit about what it is you do out at the Mississippi State Hospital.
I am the director of the Forensic Evaluation Service. So we are the only forensic service for the entire state. We do some outpatient evaluations, but now things have changed. It's mostly inpatient evaluations. And then, so we do inpatient evaluations for the court regarding competence to stand trial, someone's mental state at the time of the alleged offense, and sometimes some other factors too, such as mitigating circumstances or a violence risk assessment. Then we also provide treatment for individuals who have been found not guilty by reason of insanity, and we provide treatment for people who have been found incompetent to stand trial, and we're attempting to restore them to competence.
And you talked about the fact that you, are a forensic psychologist that do, you also perform private evaluations or do something on the side. Can you talk about that, please?
Yes, I have a private practice where I conduct forensic evaluations for both the state and the federal court. And those are typically related to the similar issues as I do for the state hospital: competence to stand trial, mental state at the time of the alleged offense. I have also done some death penalty evaluations if someone's competent to waive or assert post-conviction appeals, or competence to proceed with post-conviction appeals also.
And when you're doing these evaluations, who are you usually doing those on behalf of?
Most often it's court ordered. So it's, in my opinion, when something's court order, I consider that as the court's expert. My report goes to the court, and then both sides usually get a copy of it. Sometimes I am retained privately by one side, either the defense or the prosecution, and then I'm conducting the evaluation for them. So the person that I'm actually seeing and evaluating is not my client. It's the court or whichever attorney retained me.
And so if they're not your client, you're not actually providing them any type of treatment, right?
That's correct.
Could you give the ladies and gentlemen a little bit of information about your educational background?
I have a Bachelor of Science degree in psychology and a Bachelor of Arts degree in sociology from Lindenwood University, which is a private liberal arts school in Missouri. I received my master's in clinical psychology from the Arizona School of Professional Psychology in 2006, and I received my doctorate in clinical psychology from the Arizona School of Professional Psychology in 2008.
And do you have any type of licensure or certifications here in Mississippi?
Yes, I'm a licensed psychologist in Mississippi, and then I'm also certified as a forensic evaluator by the Department of Mental Health.
Tell us a little bit about what that means, evaluator through the Mississippi Department of Mental Health.
Yes, so the Department of Mental Health has a process where they train and credential psychologists or psychiatrists, to be forensic evaluators. So they are credentialed to do evaluations of competence to stand trial or mental state at the time of the alleged offense.
Do you know how many of them are approved in the state currently?
I'm not sure our current numbers. There are some that are approved who don't reside in Mississippi. They do telehealth evaluations. I think we have around 20 right now, maybe, but not all of them reside in Mississippi.
And so that's 20 psychologists and psychiatrists that are have meet the qualifications for the mental department of health to do the evaluations?
Yes, that meet the qualifications and have applied to do those.
Do you belong to any sort of national or state level committees, any type of groups regarding psychologists?
Yes, I'm a member of the American Psychological Association. I'm also a member of the American Psychology and Law Society, which focuses on forensic psychology. I am a member of the Mississippi Psychological Association, and I'm also the president-elect for the Mississippi Psychological Association.
And I know we talked about the fact that you perform these types of evaluations for both, most of the time for the court, but also sometimes for the party that asks. How many times would you say that you have evaluated someone either for competency or sanity?
For competency, probably around 1,500 times. For sanity, probably around 500 times.
And have you testified in courts as an expert, as a forensic psychologist previously?
Yes, I have.
And how often would you say you've done that?
Probably about, I don't know exactly, about 45 times.
And you've actually been recognized by this particular court as a forensic psychologist expert, right?
Yes, I have.
Your Honor, at this time, we would ask that the witness be tendered as an expert witness in forensic psychology.
No objection, Your Honor. I believe her CV has already been entered by stipulation.
All right, she'll be accepted as an expert in the field of forensic psychology.
Dr. Gugliano, if you could tell the ladies and gentlemen the difference in like a treating physician or therapist and a forensic psychologist.
So it's a pretty different situation. I mentioned before, whenever you are treating someone, whenever you're the clinician, either a psychiatrist or psychologist, therapist, you're more of an advocate for the client, the person that you're treating, and you are treating and assessing them based on what they're telling you usually for the most part. A lot of times treating clinicians don't have much information or records outside of what the client tells them. So they just go off of what they see in front of them and what the client tells them. In doing forensic evaluations, the person that you're actually evaluating and talking to and assessing is not your client. As I mentioned before, it's the court or potentially a lawyer. It could also be one of the parents if there's like a child custody dispute and you're doing that type of evaluation, but typically it's the lawyer or the court. And in that case, you are not an advocate for the person that you're evaluating. You are supposed to be a neutral, objective evaluator who forms opinions based on the information that you have, and you offer those to the court. So there's no guarantee that it will be helpful or not to either side or to the court. It also, when you're a forensic evaluator, it's not confidential because you have to share the information that you gather with the court in a report, or you may end up testifying. I always warn people of that also. So it's also different in that doing a forensic evaluation, because there's legal issues involved, you rely on more than just the person's self-report. It's really important to have collateral sources of information. So you are always trying to corroborate what someone tells you to see if there's evidence in the records to support what they're telling you. Other people say the same thing? You often interview friends or family, maybe even an employer. of the person that you're evaluating. So it's not as clear that you're just taking what the person tells you as the truth. You're wanting to look for corroborating evidence and find where all the data is kind of pointing you. What direction is it all suggesting?
And you spoke earlier, Dr. Gugliano, about competence and maybe somebody's sanity. If you could kind of describe for us what competency is first.
Competency in general can be applied to various different things. It's situation specific. And what it essentially means is that someone has the ability to do something. So it could be competence to make legal decisions, or competence to be over your own medical care, financial situation, things like that. In the realm of criminal cases, competence is typically referred to for competence to stand trial or to proceed with their legal situation. And so that means, does the person have the ability to understand their charges, to understand the basics about the court system and how that works, to be able to appreciate the adversarial nature of the legal system, and that they're able to assist their attorney in their defense. So competence really has to do with someone's mental functioning presently, in the current moment. Sanity, or mental state at the time of an alleged offense, has to do with how someone was doing mentally at the time of an offense sometime in the past. So it's a retrospective evaluation where you're trying to figure out whether someone was so mentally ill that it impaired their ability to know the nature, quality, or wrongfulness of their alleged acts.
And I want to talk to you a little bit about that. Is there a certain standard in the state of Mississippi that forensic psychiatrists and psychologists have to follow when rendering opinions about sanity?
Yes.
Could you tell the ladies and gentlemen about that? I think you sort of described that, but just want you to talk a little bit more about that.
Yes, the standards is what we often call the McNaughton standard, because that's the criminal case that the standard developed out of. The person who was the defendant was Daniel McNaughton. And so the McNaughton standard is what we refer to as a cognitive test. That means that it's just based on someone's knowledge about something. So it's, do they know the nature and quality? That essentially means, do they understand the basic facts about what they did? Then understanding the wrongfulness is, did they understand that what they were doing was illegal? So some states have different standards. So some states include whether someone had the ability to control their impulses or whether they appreciated the wrongfulness. But in Mississippi, it's just a knowledge of what they were doing and if it was wrong.
So I want to be clear, you said something about other states allow whether somebody appreciated what they did was right or wrong. Can you describe for us what you meant by that?
Yes. So knowledge is really just understanding the basic facts about something. Appreciating is having a more in-depth understanding to where you can understand the societal and moral implications behind it and reasoning for it. So for example, someone might know that killing someone is wrong, that it's illegal, but they may not really understand why it's wrong to do that. They know that it's bad, they know they're not supposed to, but they really don't understand why. So that would be more the appreciation, where they don't understand the reasoning behind why it's wrong.
And Mississippi doesn't allow us to talk about the appreciation of someone, right?
It doesn't include that in the standard.
I want to talk to you about the defendant, Carly Gregg. How is it that you became, or did you have the opportunity to work on an evaluation involving Carly Gregg?
I did.
And how is it that you became involved in that case?
You contacted me to see if I would be available to do an evaluation of Ms. Gregg's competence to stand trial and sanity.
And was it your understanding that you were being court ordered for that?
It was.
And is that how you went about your evaluation?
Yes, it is.
And in fact, we talked a little bit about how that's different, but when you're court ordered to do it, you said you returned that report to the court and the defense attorneys, right?
Yes, actually in Mississippi, I submit my report to the circuit clerk, and then the circuit clerk distributes it to the judge, defense attorney, and prosecution.
Does the prosecution have any ability to edit the report that you prepare?
No.
Does the prosecution actually really have any input into what you put into your report?
No.
And sometimes those reports actually come back and say that the defendant is incompetent to go forward, right?
Correct.
And sometimes you will render an opinion that the defendant is in fact insane.
Correct.
I want to talk to you about this particular case. Dr. Gugliano, did you prepare a report regarding your findings?
I did.
And are the opinions that you formulated in that report, are those based upon a reasonable degree of medical certainty?
To a reasonable degree of psychological certainty, because I'm not a medical doctor, so we use psychological certainty for psychologist.
Thank you for that clarification. And what types of items did you review before rendering your opinion in this case?
I reviewed some court orders involving this case. I reviewed some of the discovery materials. I also had some treatment records, not all of the ones that have been talked about so far by other experts. I had the Magnolia counseling records, so Ms. Kirk's records from the therapy. I also had precise clinical neurosciences records from the medication that she was being prescribed. I had a few records from the jail from her current incarceration related to some crisis contacts, but I did not have any records regarding the medication that she was being prescribed in jail. Then I also spoke with Ms. Newman about her concerns regarding the case, and I spoke to Ms. Todd, the defense attorney, about any concerns she had regarding the case.
Did you interview anybody besides the defendant in this case?
No, I attempted to interview her stepfather, but he had asked to have his attorney present, which I said was okay, and he was going to call me back where we could set up a time to do that, but he never returned my call.
Why is it important to try to talk to family members before you conduct your evaluation?
I do that because I'm trying to see if there's anything that they say that that will give me an idea of what to follow up on, or there may be something that isn't in the records that they're aware of. And sometimes they can give you a direction to go with your questioning. I do a pretty broad evaluation, but if there are any significant concerns or specific concerns, I want to make sure that I know about them so I can ask about them when I interview the defendant.
And Dr. Gugliano, you just testified about some of the things that you reviewed, that you had conversations with both my office and the defense. Is that information, facts, and data that you typically rely on in conducting your mental health evaluations?
Yes, it is.
And is that information that is pretty regular for a forensic psychologist to consider when forming their opinions with regards to competency or sanity?
Yes.
Did you actually have the opportunity to speak with Ms. Gregg?
Yes, I did.
Was that interview recorded?
It was.
And do you record all your interviews?
I record most of them. There's a few times that I haven't for the federal courts because the attorneys have not wanted me to.
And why is it that you record those interviews?
I record them in case I need to refer back to my notes. I take notes while I'm interviewing someone, but I like to be as accurate as possible, and I really think that quotes are helpful for either a court or a jury, for either the judge or the jury, whoever's making the decision, to see what people actually say. So I record it for my benefit, and then I also record it in case someone wants to get the recording so they can listen to it. I try to have transparency in my evaluations. I'm not trying to do anything that I wouldn't want recorded. So it's to help just confirm what I'm reporting in my report.
When you're conducting one of these evaluations, Dr. Gugliano, is it your role to favor one side or the other?
No, as a forensic evaluator, your goal is to be as objective and unbiased and neutral as possible.
How often, when you're doing these evaluations, do you actually have mental health records from the day before a crime was committed?
Very rarely.
And how often do you get the opportunity to have a video where part of the crime is committed on the video to consider? It's not unheard of, but it's not in the majority of cases. I want to talk to you about the interview that you did at the defendant. Who was present during that evaluation?
It was myself, Miss Gregg, and Miss Todd.
And is it common in your practice for attorneys to be present during the evaluations?
I wouldn't say that it's uncommon. It doesn't happen in the majority of cases, but it's not unusual.
How often, when you have attorneys sit in, is it common for them to make comments during the evaluation?
Most attorneys don't say much during the evaluation unless the defendant asks them a question. I always let both the defendant and the attorney know at the beginning that if the defendant wants to consult with their attorney during the evaluation, we can stop and they can consult in private, or the defendant can even ask their attorney for guidance at any point without us also stopping the interview. So it happens, but most of the time when it happens, it's the defendant who initiates the consult with the attorney in the moment.
And in your training and experience and all the evaluations that you perform, is it unusual for an attorney to be asking their client multiple questions instead of you during an evaluation?
Yes, I would say that's unusual.
Dr. Gugliano, I want to talk to you about the specific findings in your evaluation. Can you tell us when you conducted that evaluation and sort of walk us through what happened?
We met in a room at the detention center, and it was for several hours. I think we were probably meeting for about 5 hours, but we had several brief breaks in that time to where the interview was a little over 4 hours, and we had a break for lunch also. But essentially it was me asking the majority of the questions to Miss Gregg, and Miss Todd interjected at some points, but that was pretty much it.
Were there things that Ms. Todd shared with you that were not provided to you in discovery?
Yes.
Is that typical in cases when you have evaluations?
It's not unheard of. Ms. Todd shared some things with me on the phone. I talked to her before I met with Ms. Gregg to do the interview. So she had shared some things with me on the phone that I was not aware of at that point. And that's one of the reasons that I call attorneys, is to see if they have any information that may be helpful.
And when they give you that information, you then try to follow up, get some sort of confirmation about those statements or what that information was?
Yes.
What, if anything, did Ms. Gregg tell you during your evaluation about the use of illegal drugs?
She told me that she was smoking marijuana through a vape pen, and she denied any other illicit or illegal substance use.
What did she tell you about abusing any other prescription medication?
She didn't answer that question.
And was that important to you?
It's a regular question that I ask when doing an evaluation. Both illegal drugs and prescription drugs, or even over-the-counter medications, can have impacts on someone's mental health or in their functioning. So I routinely ask those questions.
And if someone were to have been on a prescription drug at the time of the crime, it would have been important for you to be able to explore that a little bit further, right?
I would definitely want to know if they were on medications at the time, or if they were taking anything that wasn't prescribed to them.
And if so somebody wasn't truthful or didn't provide you an answer about that, that would impair your ability to make a decision about anything regarding medication. Is that correct?
It might not impair my ability. I'm limited in what I can say about medications. I don't prescribe medications, so I'm limited in what I can say about that, but it could limit things such as, it might be a consideration that someone's actions, feelings, behaviors could have potentially been due to a drug or medication. And so if you don't know that they were using that, then you wouldn't know that that's a potential factor.
I want to back up just a little bit. The defendant told you that she'd been using marijuana. You have the opportunity to review prior medical records in this case. Did you see anywhere in her prior records where she had reported the use of marijuana?
I believe she had reported it to the jail, maybe, after she was arrested.
Prior to March 19th of 2024, had she told any of her treaters that she was using marijuana?
From the records that I reviewed, she had not.
From the records that you reviewed prior to March the 19th, 2024, had she ever reported to anyone that she was having voices in her head?
No, she did not.
Prior to March 19th of 2024, in the records you reviewed, had she reported to anyone that she was having lapses in time?
She did not.
And did you find anything that was provided to you by either side to corroborate that Ms. Gregg was having lapses in time?
Ms. Todd told me during our telephone conversation that Ms. Gregg's stepfather had mentioned that Ms. Gregg was having lapses in time and kind of spacing out. And so I asked Ms. Gregg about that during my interview of her.
But you weren't able to corroborate that with him?
No, I wasn't able to speak with Mr. Smiley.
I want to talk to you about the use of marijuana. In your experience, can the use of drugs alone cause some sort of psychosis?
It can.
And what about marijuana or THC alone?
It can. We thought previously there was a common belief that marijuana was fairly benign, but there are higher levels of THC in most marijuana now, or a lot of marijuana now. And so with the more potent marijuana, it is possible that people can experience symptoms of psychosis just from marijuana use.
When we're talking about symptoms of psychosis, can you describe for us what you mean by that?
That could be hallucinations, such as seeing things or hearing things that aren't really there and that other people don't see. It could be delusional beliefs, which are beliefs that are untrue, but the person staunchly believes that regardless of the facts or evidence presented to them that dispute those beliefs. It could also be mood symptoms like an emotional flattening to where they don't seem to have the normal range of emotions that most people experience. It could even be slowed thinking or slowed body movements.
During your interview with Miss Gregg, did you talk to her about some things that might have been bothering her at the current time?
Yes, I did.
Could you tell us a little bit about that?
Yes, may I refer to my...
Absolutely.
I always ask people that I'm evaluating, if you had to pick the one thing that was bothering you the most lately, what would that be? Because it's a pretty open-ended question, and it can kind of give you a good idea of what is, on that person's mind maybe the most. And Miss Gregg reported that she was bothered that she knew school was getting ready to start up or had just started back, and she missed school because she said she really enjoyed school and that had been a main focus of her life. She also discussed feelings of sadness, difficulty sleeping. She reported having mood swings.
What did she say about her mood swings?
She said that they could occur minute by minute or could happen over the course of weeks or days or months. She said, when I asked her to provide some additional clarification, she said, quote, "I'll be really happy one minute, then I'll be desolate the next," close quote. So she was describing, it seemed to me, pretty quickly fluctuating mood states that appeared at least somewhat dependent on her situation and what was going on with her in her life.
Dr. Gugliano, you were in the courtroom during the testimony earlier where somebody had mentioned that Miss Gregg's father potentially had bipolar disorder. Can you describe for the ladies and gentlemen what bipolar disorder, I think it's type 2, is?
Yes, there's two different types. I'm not sure which one Mr. Gregg has been diagnosed with. Type 1 involves episodes of mania, which you guys had heard about previously. It's whenever someone has the really high emotional experiences, they have a lot of energy, they may feel like they're on top of the world, really happy, feel invincible, have trouble focusing. They may start a whole bunch of tasks but never finish anything. They can be more irritable. And it's so severe that it impairs their everyday functioning. Then bipolar 2 disorder is kind of a less extreme version of mania that we refer to as hypomania, where they're elevated more than what is normal, but it's not quite to what we consider a manic episode.
And when you're talking about a hypomanic or an episode in bipolar, is that consistent with somebody whose mood can change minute to minute?
No.
Could you describe for us why not?
Yes, for bipolar disorder, it's something that isn't based on someone's situation. They really have no control over their emotions. It's not due to something good happening in their life or something bad that's happened in their life. And for a diagnosis of bipolar disorder, they have to experience either the manic episode for 1 week, where from every day, more days than not, that they're in this hyper aroused state. For hypomania, they have to experience it for at least 4 days in a row. And so that's not something where you would see fluctuations within the same day or hours.
In your evaluation with Carly and your review of the medical records, was it ever disclosed that she had these periods of time that were 4 days or more?
She didn't specify an exact number of days. As I mentioned before, she said, it could be hours, days, weeks.
you spoke with Miss Gregg about mood swings, and then she described for you at some point during your interview, I'm very detached. And I think you asked her to elaborate on that. Do you recall what Miss Gregg told you regarding feeling detached?
Yes. So I was asking her questions that can sometimes be commonly found in people who have experienced traumatic experiences. So symptoms that sometimes indicate someone may have post-traumatic stress disorder. And we were talking about anxiety also, and how she didn't feel as bothered as she thought she should have felt by being in jail. And so I was asking her more about that, and Miss Todd offered that Miss Gregg appeared to be detached, and that Miss Todd thought that might have been due to Miss Gregg being in solitary confinement. She'd been housed by herself in the jail since she's a minor, so she has little interaction with other people other than the guards when they interact with her. And so I asked Carly about that, and she said, I'm very detached. And she said, and when I asked her to describe that a little further, she said, quote, I think when my mom would get on me, I would kind of slip away and not be in the room. I just kind of feel like it wasn't real. I think that's how I am now because all this doesn't feel real. I mean, logically it is, it just doesn't feel that way, close quote.
And then you went on, Dr. Gugliano, to ask her about blackouts. Can you tell, ladies and gentlemen, what y'all's conversation about blackouts was?
Yes.
For reference, I think that's on the same page we were just looking at, same paragraph.
Okay. I had asked her if she ever experienced a blackout, and she said that's kind of what happened with the incident, the alleged offense. She discussed further about the blackout, saying that she would just kind of space out, and I believe she said in particular whenever, like if her mom was yelling at her, she was in trouble with her mom or something like that.
Did she ever use the words derealized?
She did not.
What about the word disassociation or disassociated?
No, she did not use those words.
Did she reveal to you that she was having intrusive memories regarding the crimes committed in this case?
Yes, she did.
Could you tell ladies and gentlemen about that?
Yes, so intrusive memories are just memories that someone is doing something else, they're not purposefully thinking about something, and the memories just pop into their head. And once they get in their head and once they're thinking about them, it's really hard to stop thinking about them. It's hard to let go of those memories. And so I don't think at that point that I asked her for details about the intrusive memories regarding the offenses, because I had not yet determined whether she was competent to stand trial, and talking about that could have potentially revealed incriminating information. So I was waiting until later to ask that, and we never ended up circling back to that.
And Dr. Gugliano, was there anything about your conversation where somebody said something about feeling queasy when they were thinking about the event?
Yes.
Tell me about that, if you would.
Carly reported that sometimes when she thought about the alleged offenses that she would feel queasy.
And what else did she say about being paranoid?
She described having thoughts that bad things were going to happen, such as that someone would jump on her in the jail or things like that. And in my experience and opinion, that's more consistent with anxiety than delusional paranoia. Whenever people kind of have those thoughts where they just worry about all these things that could potentially happen, that is symptomatic. You know, they often say that I'm paranoid that these things are going to happen, but they're not using it in the clinical sense of paranoia, and it's not what I would think of in the clinical sense as paranoia, as like psychotic paranoia.
I want to take a step back, Dr. Gugliano. The word queasy, and you talked about that Carly said she felt queasy when thinking about the event. Can you elaborate on what that meant?
I didn't ask her, but I was assuming that it meant sick to her stomach.
About the crimes that have been committed?
About something in relation to them. I didn't ask for any specifics.
At some point, Dr. Gugliano, did you have a discussion with Carly about whether or not she was hearing voices?
Yes, I did.
And what did she say about the voices?
She said that she had been hearing one voice, a male voice, since she was young. I think she said maybe around like 5 or 6 years old, which is unusual. And she said that she heard the voice every day and that it was always kind of there in the background, but she could usually ignore it and tune it out.
You said that it was unusual that somebody would start hearing a voice at 5 or 6. Can you tell us why?
Yeah, that's not really consistent with psychotic disorder. Typically, people start having symptoms of psychosis for women in their early to mid 20s. For men, it's late teens, early 20s. It's very unusual for a young child, to have what are actually hallucinations. And it's possible that it wasn't what we would clinically consider a hallucination. It could be, you know, as a kid, it could be something like their own inner thoughts or their inner dialogue, and they don't recognize that as what that is.
She described those voices that she was hearing them every single day.
Yes.
Is that common in people in that age group?
No.
What did she say about whether or not these voices ever told her to do anything?
She said the voices never told her to do anything. She said that they made snide comments about other people and just really rude comments, kind of talking down about other people. I specifically asked her if the voices ever told her or said anything about her mom or her stepdad, and she said no.
You were present in the courtroom yesterday during Dr. Clark's testimony, right?
Yes.
And you heard mention that Carly had disclosed to an employee through Vital Court that in fact her mom, she heard voices that told her to harm her mom.
Yes, that's what Dr. Clark said.
So there's records saying Carly said, the voices told me to hurt mom, but that's not what she reported to you.
Correct.
Dr. Gugliano, as part of your evaluation regarding competency, one of the things you consider is the defendant's ability to recall facts. Could you tell the ladies and gentlemen why that's important?
That is a requirement specifically for Mississippi. Most other states don't have that as part of their competence to stand trial requirement. There's not a clear definition of what is specifically meant by that in the standard. The general interpretation that I have for it is that it means that someone can recall basic information about their case. If they have a discussion with their attorney, are they able to remember what they talked about? What do they remember about the alleged offenses? If they don't have a good memory or don't remember the alleged offenses, are they able to go over the evidence and remember the evidence enough to be able to help their attorney prepare their defense?
And in this case, what did you find regarding Ms. Gregg's ability to remember relevant facts about the alleged offense?
It was my opinion that she had the ability to recall relevant facts. We talked about the month leading up to the alleged offenses and what all was going on with her then, and her report was fairly consistent with the records that I had available. She also did not demonstrate any current memory deficits that would have been concerning. So I didn't talk to her about that day in particular because I didn't end up evaluating her sanity at the time of the alleged offense. So I don't know exactly what all she recalls from that particular day.
With regards to your evaluation, did you in fact find a forensic opinion regarding Carly's ability to proceed to trial and competency?
Yes, it was my opinion that she had the ability to do so.
And is that to a reasonable degree of psychological certainty?
It is.
And again, just to kind of go through those factors with us, the ability to understand the nature and the proceedings against her.
Yes.
And then what else is that?
The ability to rationally communicate with her attorney about her case, the ability to recall relevant facts, and the ability to testify in her own defense if she chose to do so.
And in fact, you found that Carly was competent.
That was my opinion. I don't decide that. That's up to the court to decide.
And in this particular case, Dr. Gugliano, did you send your report to the clerk's office like you do when you're court ordered to perform an evaluation?
I did.
No further questions, Your Honor.
Lunch is here and set up and ready for y'all, so we're going to take a recess till at least 12:30. Remember not to discuss anything about the case at this point. Everyone, just whenever you're done, around 12:30 or thereafter, it's y'all's lunch, knock on the door and let the bailiffs know you're ready. Okay, everyone, please remain seated while the jury exits. All right, the record will reflect we're outside the presence of the jury. Dr. Gugliano, you'll be free to leave during lunch. Be back no later than 12:30. No later, I mean 12:20.
Yes, sir.
Okay. We'll be in recess till. Do not discuss your testimony with anybody. Okay. The court will be in recess till at least 12:20. All right. See y'all then. State ready.
Yes, sir, Your Honor.
Fence ready.
Your Honor, before we bring the jury back in,
Okay.
there's an issue that we need to take out.
All right. I hear you.
Your Honor, just now, the defense received exculpatory evidence from one of the minors, BG's, whose phone had been turned over to law enforcement, and law enforcement downloaded contents of his phone. However, these text messages were not provided to us until BG himself provided them to us earlier today. This was a phone that was taken into custody by Zach Cotton on March 19th. If you look at the state's Bates numbered document 283, is actually his arrest, the search warrant for that phone. Now, while they did provide us text messages from the day of March 19th, they did not provide us any of the other text messages. BG found these text messages on his phone and texted them to myself earlier today. I printed them out on the lunch break, and according to both the United States Supreme Court case law, Brady v. Maryland, Mississippi, King v. State, and also Arizona v. Virginia, which is a U.S. Supreme Court state, the failure of law enforcement to disclose exculpatory evidence is imputed to the state, and such disclosure mandates either a continuance until the defense has had time to review this documentation, or dismissal of the charges themselves for the failure to provide exculpatory evidence in discovery.
You want to mark?
Yes, Your Honor, I would like to mark on Friday.
All right, I'll be marked Friday purposes only.
Can we look at it? Yeah, got the copy right here.
I mean, I have a response in general without looking at them.
Hang on. Take a look at them. What were they marked? 23 ID only.
Your Honor. The date is on the top text message. Is the one in general that we believe goes to the exculpatory evidence. It
Okay.
is on this page. So it would be this page. BG is in blue, Carly is the black.
Where it says do it back? Is that the first text message?
Yes.
All right. So the defendant says do it back. Mr. Bennett Germany says, I don't know what that is. What's going on? She responds, I don't know. I called Anthony because I wanted to talk to him. And then I saw him and I couldn't breathe. And I couldn't say anything because I didn't know what to say. And I can't remember anything that happened today. I zoned out for most of it and I don't know what's wrong with me. That's what you're
Yes,
showing
sir.
as the exculpatory part.
Yes, Your Honor. And that this text thread is dated as of November 22nd of 2023.
All right. Anything further from the defendant?
Not-
By way of motion.
No, Your Honor, just that the U.S. Supreme Court and also the Mississippi State Supreme Court is clear about the failure of the fact that it was in the possession of law enforcement. Law enforcement downloaded the contents of this phone, had it by search warrant, and failed to produce it. And the failure, and according to the U.S. Supreme Court in Arizona v. Youngblood, the failure of law enforcement is imputed to the failure of the state for discovery purposes.
Okay. Response by the state, or do you need a few moments?
I'm prepared, Your Honor. First of all, I don't believe
Well,
that text
let's-
message.
Let's step up to the podium.
I may have to go upstairs at some point and get a signed piece of paper from Ms. Todd, but I think that I have it here. Your Honor, first let me address the fact that this is not, in fact, exculpatory material. This is a text message between Bennett Germany and the defendant from back in November. Bennett Germany took the stand. He could have provided this at any point. He actually, in fact, spoke to the defense attorneys previously. This is not new information that they had. It's not exculpatory information. However, in order for it to be a Brady violation, the state would, in fact, not have had to produce the material that they had. On June the 4th, 2024, the state of Mississippi provided to the defense attorneys one jump drive containing digital evidence media files, witness interviews of minor friends, the indictment, discovery bait stamps 1 through 349, supplemental discovery bait stamps 350, 351, third Snapchat report 352, 356, 2 CDs labeled Heath Smiley hospital interview and Deputy Allison Dufour body cam, and 1 hard drive containing phone dumps. Your Honor, they were in fact provided the phone extraction from Bennett Germany's phone. It is not the state's fault that they did not review those messages. Everything that was on Bennett's phone that was taken from law enforcement was produced to the defense attorney on June the 4th, 2024. Since there had been issues with the state of Mississippi and the defense attorneys claiming that they had not in fact received items, the state went ahead and had them sign something stating that they had received discovery, and also the entire jump drive, now not the external hard drive, but the jump drive that was provided that had the media and electronic data on it was screenshotted. Ms. Todd signed off on April the 20th, 2024 that she had received all those items, including through bait stamps number 798. When Mr. Camp reached out to me the day before the defense attorneys had provided their expert discovery, I believe it's by email, I can go back and look, Your Honor, I believe responding to him around 5 o'clock, he said something to the effect of, where are the text messages between the kids? And my response was, well, there's two places. There's screenshots that you guys were provided, and then there's messages within the actual phone extractions. Your Honor, they had this material, they knew this material existed, and for them to try to claim now that they were not provided that information is disingenuous. And again, this witness took the stand. If they knew this, if he knew this, if they had this information, they met with him previously, why on earth would they be producing it now? We do not believe this is exculpatory. This is something that happened back in November. We're here because the state has charged Carly Gregg with murdering her mother on March the 19th, 2024. We are here because the state has charged Carly Gregg with attempting to murder her stepfather, Heath Smiley, on March the 19th, 2024. And we are here because the state has charged Carly Gregg with tampering with physical evidence for removing the surveillance footage that captured a portion of the incident and hid it in the refrigerator. There is nothing about this text message that would indicate that it is anything other than messages between the defendant and one of her friends who on the stand said he was her best friend. This has not been authenticated. I don't know, Your Honor, without going and putting the phone extraction into my computer whether or not this message is actually there. But if it is, they've had it since June.
Hold on a second.
May I respond, Your Honor?
In a second. I'm going to give you a chance to reply. All right. What documentation do you have to prove that you turned this over to the defense? I believe you said there was a jump drive that contained the phone extract, and I'm familiar with phone extractions, that there's no way to extract part of a phone on Celebrite.
That's right, Your Honor.
Okay. So did you show me what you got to prove that you turned over a jump drive?
Of course,
And if you need a few minutes to go grab your paperwork, you
I
go.
do not, Judge.
Show it to counsel opposite.
We've had this issue come up previously, so now we have the defense attorney sign saying they picked up material.
All right. Do you have a copy of that we can mark for identification
This is
purposes?
the only one I have, Your Honor. I can rip it out of the file and make a copy if necessary.
All right. You showed it to counsel opposite, correct?
Yes, Your Honor.
All right. Mark it for identification purposes for the state.
Your Honor, for the record, that bears Ms. Todd's signature and date.
Okay. Let's mark it so I can see it. All right, and what you're saying is this jump drive contained digital discovery. Is that correct?
Your Honor, there was a jump drive that the defense brought to our office. That jump drive contained the digital discovery, the physical file, the PDFs, the 2 CDs that we had in our file, as well as we had an external hard drive that had these phone extractions on them. They were put onto the jump drive that Ms. Todd picked up on June the 4th, 2024, as indicated by a hard drive containing phone dumps. Your Honor, there are multiple emails between myself and Ms. Todd that if I need to, I can run upstairs and print off where I've said, let me know if you can't open a file. Let me know if you don't have something. I said, in fact, hey, I screenshotted 800 pages and scanned it in. Let me know if a single file doesn't open. Mr. Camp and Ms. Todd were attached to all those messages. At no point did they ever say, hey, we don't have Bennett's phone extraction. Again, just because they don't know how to access something, they didn't ask our office for something, or they didn't take the time to review that material, Judge, does not put that burden on the state.
Is there anything else the state wants to move in for the court to look at?
Your Honor, I'd like an opportunity to go upstairs and print all those emails I've talked about, if that would assist the court in any way.
Sure. Can you do it within 10 minutes?
I believe so.
All right, we'll be in recess 10 minutes.
In fact,
I'm going to
Mayor-
give you a chance to reply, but I want to see her. It's going to go motion, response, reply, I rule, we're done.
This is not reply was cleared up, Your Honor.
Nope, not till I see her documents. I want to complete the state's response. That way you can have a reply. We're not going to have a reply, response, or reply. It's going to be motion, response, reply, I rule, and the rest of it's up to the appellate courts. All right, y'all got 10 minutes.
Your Honor, I believe that I could probably just make a copy of all of this, and that would entail my emails back and forth with Ms. Todd regarding discovery. I kept them because I assumed that there at some point would be some sort of argument that we hadn't produced something. But I do not have a copy of this. This is just the one copy I kept for my file.
Well, I saw Mr. McDivitt stand up back there. He can make himself useful and cut down on the jury's time. I think everybody in the courtroom knows I don't have a problem abusing lawyers and their staff. So give him the
Yep.
email, the email. Mr. McDivitt, you go copy it.
I think that should be everything. I'm going to make sure that's all of it.
And please bear in mind, I got a jury waiting.
The problem is there's a bunch of staples in it, but I don't know what I got. But I'll keep it. Thanks, sir.
All right. Ms. Gugliano, still don't discuss your testimony with anybody. Well, let me ask this. While he's making copies, would there be some objection to us going on ahead and hearing her testimony? I mean, you're asking me to dismiss the charges, basically, Ms. Todd, correct?
Yeah.
Okay. Well, if I don't decide to dismiss the charges, we're going to hear Ms. Gugliano's testimony anyway. So rather than wasting the jury's time, I'm going to bring the jury in, let you cross-examine her, let them redirect, and then I can take another break, and maybe copies will be done by then. I'll hear objections to that procedure by the state.
No objection.
Objections to that procedure by the defense.
No, Your Honor.
All right, let's bring in the jury. Ms. Newman, get your notes. Have a seat. And everybody take a deep breath. All right, ladies and gentlemen, as I said, every day, after lunch hour, things get slow, people get a little tired. If you get tired at any point in time, just stand up, okay? Stand up, try to shake off the afternoon sleepies. All right. Dr. Gugliano, do you understand you're still under oath and your answers are still sworn answers?
Yes, Your Honor.
Did you discuss your testimony with anyone during the break?
No, I did
All right, you may proceed. Cross-examination.
Good afternoon, Dr. G.
Good afternoon.
If you recall during your direct examination, Ms. Newman asked you about information you received from me. Is it correct in my understanding that you called me?
Yes.
Okay. And I provided information upon your request?
Yes, you did.
Okay. And during an evaluation, when you're evaluating a minor or any person, who's in control of that evaluation?
I am.
And if you felt for any reason that your evaluation was being hindered, either by something with the location or anything else, what would you do?
I would try to take steps if I could to correct it.
Okay. And Dr. G, you mentioned on direct examination with Ms. Newman that there was an occasion in which I interjected or interrupted during your evaluation of Carly.
Yes.
And was that because there was a time or two in which I was aware that Carly was trying to answer a question for you that she didn't know the answer to?
There were a few times where you interjected to tell Carly not to answer if she didn't know, or to just say she did not know. And then there were times that you interjected to prompt Carly.
Yeah, to make sure you had all the information, correct?
I can't say what your intentions were. I'm just saying
no.
you
Yeah.
prompted her by giving her, a word or something like that, or mentioning, remember this.
Okay. And Dr. G, you were originally there to do an evaluation on Carly's competency to stand trial and to determine whether or not she was competent at the time of the incident on March 19th. Is that correct?
Yes, her competence at the time to stand trial and her sanity at the time of the alleged offenses.
Okay. And can you, explain, but in the course of your evaluation, you ended up just evaluating whether or not Carly was competent to stand trial, correct?
That's correct.
And that's very different than whether or not she was actually competent at the time of the incident, correct?
Yes.
Okay. And you have testified for this court once before at a competency hearing. Do you recall that?
In this specific case? Or?
Yes, in this case. Yes. And do you recall your testimony in that case that you informed the court that you stopped your evaluation because you became aware that medication might be an issue in Carly's competency at the time on March 19th, and you felt like there was someone else who could evaluate that?
Yes, it was my opinion that it appeared we had started talking, as I mentioned before, about what was going on with Ms. Gregg in the month leading up to the alleged offenses, and she mentioned her psychiatric medications and how she stopped one medication and started another a week before the alleged offenses, and that she had some reactions to those medications. So I recommended that a psychiatrist, a forensic psychiatrist, do the evaluation because I could not address whether any side effects or withdrawal symptoms may have been present due to medication, since that's not a specialty area of mine.
Thank you. I tender the witness, Your Honor.
Redirect examination.
Dr. Gugliano, in fact, you did try to question Ms. Gregg about whether or not she abused prescription medication, didn't you?
I did.
And she refused to provide an answer.
She declined to answer the question.
And are you able to go forward with any evaluation about medication when somebody fails to provide you information about it? Their abuse of medication.
If their abuse, no. No, if you're asking specifically about abuse, no, but there are other questions that I would have asked later in the interview about medications if I was evaluating her sanity.
And I believe you shared earlier that you did in fact render an opinion regarding her competency and her ability to recall facts, and that was that she is competent. Is that correct?
Yes, it was my opinion that she was competent to recall facts in relation to being competent to stand trial. I'm not saying how much she may or may not be able to recall of the alleged offenses.
No further questions, Your Honor.
May this witness be finally excused by the state?
Yes, sir.
By the defense?
Yes, Your Honor.
All right, y'all approach. You can stand in.
Thank you.
Apologize, this is my fault, okay? We have some things that we have to take up outside your presence. I'm going to ask you to go ahead, step back to the jury room for just hopefully a few minutes. When I say a few, 20, maybe 30, and I apologize, this is my fault, okay? So I know it's in and out, but nonetheless, just take a breather, give us about 30 minutes, all right? Everyone remain seated while the jury exits.
I'm going to take about a 10-minute recess, and hopefully the emails will be back before then. All right?
Mr. Garner, and I found some more. I'm going to go upstairs and get them to add those to this.
All right. We'll be in recess till 1:05.